And we are recording.
Hey, let's call this meeting to order at 4:03. Please call first item.
Item number 1, call to order, roll call, and agenda changes. Did you want to announce the meeting, Bruce?
Yeah, hold on. I need to bring up something here. Okay, there we go. Hold on, I lost my agenda. 1 second. Problem with electronics. Full task force. Okay, here we go. Okay, all right, please call the roll.
You want to announce the meeting?
I did.
No, you didn't.
Yes, I did. I said, let's call this meeting to order at 4:03.
She means the preamble.
Oh, the preamble.
This is the Sunshine Task Force meeting date.
Okay, this is Sunshine Ordinance Task Force, June 2nd, 2021. At 4:00, right now it's 4:00, coming up 4:05 p.m. Please call the roll.
Member Schmidt?
Aye.
Member Schmidt?
Oh, present, sorry.
Member LaHood?
Present.
Member LaHood present. Member Frazier? Member Frazier? Member Frazier not present.
Oh, yeah, Member Frazier is excused.
Oh, excuse.
Contacted me for medical.
Member Padmanabhan?
Present.
Member Padmanabhan present. Member Wong?
Present.
Member Wong present. Member Stein?
Present.
Member Stein present. Vice Chair Yankee?
Present.
Vice Chair Yankee present. Member Highland?
Present.
Member Highland present. Member Neighbors?
Present.
Member Neighbors present. Member Forsley emailed me that she might be appearing at 5 p.m. tonight, Bruce.
Yes, I got that same message.
All right. Chair Wolf?
Present.
Chair Wolf present. We have a quorum.
Okay, thank you. Any adjustments or changes to the agenda?
Yes, we heard from Zach Karnazes asking for a reasonable accommodation that his case be heard earlier in the agenda than is scheduled in the agenda. He wants to be first.
Okay, and when did he contact us for that?
I believe it was May 18. It was
May-
time.
Okay. All right, members, shall we adjust the order of the agenda?
Sure.
Well, need a motion to do that.
This is Member Stein. I make a motion to allow Mr. Karnazes to be first in the agenda.
Second, Mr. Schmidt, Member Schmidt.
Okay, so moved by Member Stein, second by Member Schmidt. I will just ask, is the Mayor's Office on Disability present? Because they may have planned to come later.
Yes, we are here.
You are here. All right, would you be prepared to go first?
This is Deborah Kaplan with the Mayor's Office on Disability.
Hi, Ms. Kaplan. If we move this item to the top of the agenda, are you prepared?
Yes,
You are. Okay, Frank. And Mr. Zernakis, are you? Karnazes, are you here?
Hear me?
Yes. Go ahead, Kate. Wait, you're here?
Hi, I think the system just unmuted me. This is Zach Carnegie.
Okay. And so both parties are here. Okay. All right. Members, any further discussion on moving this item number 7 to item number 3? And then all other items will be moved down appropriately. Hearing none, let's open it for public comment. Public comment on the changes to the agenda.
Yes. May I make a comment?
Yeah, one moment. Waiting for the administrator to get the clock ready.
I'm ready for the first speaker.
Hi, this is Zach Carnegie. This is a public comment for the agenda moving. Is that correct?
Correct.
Thank you. I appreciate the granting of this accommodation. It's really important for me because I have multiple severe disabilities. I'm in a lot of pain right now, and I cannot endure really long meetings. So I really appreciate it. I just wanted to clarify. I was just asking to be for item number 7 to be the first of the items heard today. I was not asking to be in front of general public comment or other like sort of, preliminary things that this body does. Thank you.
Next speaker.
Hang on. We have another speaker.
Perhaps me.
Go ahead, sir.
This is Peter Warfield, Executive Director, Library Users Association. You can be reached at libraryusers2004@yahoo.com and PO Box 170544, San Francisco, California 94117-0544. We have the position of first hearing on the agenda, and we have absolutely no problem whatsoever in accommodating the request for precedence for Zach Carnegie. Thank you very much.
Any other public comment? Last call for public comment. Okay, public comment is closed. Are we ready for a vote? Okay, please call the roll.
Member Stein?
Aye.
Member Stein, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Frazier, not present. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Forsley, not present. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Present. Aye. I'm sorry.
Okay. The motion to allow item 7 become item 1 or item 3 on the agenda passes.
Okay, great. And just keep note, Cheryl, of the all the other files moving down one step. Okay. All right. Let's do our opening statements.
Shall I begin?
Yes, please.
Remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency issued on February 25th, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfgos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Shall I read meeting decorum?
I'll read it. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. I also have a communication from the Sunshine Ordinance Task Force. We'd like to make a statement about recent public comments that have inaccurately referred to the hashtag Say Your Name campaign and referencing others. As per their website, quote, launched in December 2014 by the African American Policy Forum, AAPF, and Center for Intersectionality and Social Policy Studies, CISPS, the hashtag Say Her Name campaign brings awareness to the often invisible names and stories of Black women and girls who have been victimized by racist police violence and provides support to their families, unquote. The week of May, again, a quote from the same website, the week of May 20th, 2015, AAPF and CISPS, in partnership with Andrea Ritchie, released a report entitled Say Her Name, Resisting Police Brutality Against Black Women, which outlined the goals and objective of the hashtag Say Her Name movement. The report provides an intersectional framework for understanding Black women's susceptibility to police brutality and state-sanctioned violence and offers suggestions on how to effectively mobilize various communities and empower them to advocate for racial justice, unquote. We, the Sunshine Ordinance Task Force, acknowledge the structural inequality and racial bias that disproportionately affects communities of color and the goals of the hashtag Say Your Name campaign, among others, which are not to be taken lightly or appropriated by those outside of such communities. We will address concerns with public commenters directly and any other parties, and we appreciate those who have contacted us and urge you to continue to do so, that we may, here in this chamber, set an example for all meeting bodies, and so we may continue our own due diligence and self-education. Okay, let's move to the next item, item number 2.
Item number 2, approval of the minutes from the Sunshine Ordinance Task Force May 5, 2021 meeting. I have to say that in trying to get the minutes prepared, Matthew and I worked on it on Friday, and as I thought I was saving the correct version, I wasn't. And so the version that has been included in today's agenda is not correct. What is uploaded is correct on the website, but I think we should forward this last month's minutes to July.
Oh, you want to, okay.
Sorry, Matthew, it's not your fault, it's mine. Just
Oh, that's okay.
Wait, one moment here. Oh, that was the May 5th minutes. Okay. All right.
it was just a Shane Andery's matter. There was a motion that Matthew wanted me to include that hadn't been included originally.
Okay. All right.
Actually, Cheryl, it looks like you have the version that we worked on together.
It's on the website, but she said what was sent out to people, so other people received an incorrect version.
Oh, I see what you're saying. Okay, I was gonna say it's okay. Yeah, I got you.
Okay. Other than that one issue, is the rest of it okay? Or are there other issues with the minutes? Cheryl?
That was the only issue that I saw. Nobody has, unless somebody has something to address now.
Right. So let's do this. I mean, we can, because the bulk of or most of the minutes, you're identifying as being correct, except for that one item. Then why don't we take any other comments from members and from the public? Let's get this on the floor, and then we can decide whether it should be postponed or not at that point. Otherwise, we can pass at least what we get as additional information and have everything corrected, and then we can decide whether we want to bring it back next month or approve it with the items that are missing. And if the items that are missing on your end, Cheryl, are substantive, then we'll consider postponing at that time. So let's get this on the floor so we can have some discussion. Is there a motion?
Can I just add one thing, Bruce?
Yes.
It was just the Shane Anderes matter.
Was it the whole section that's missing?
No. Section.
I'm sorry?
There were 4 motions, not 3.
There were 4 motions, not 3.
Yes.
Okay.
So that's the only issue with the minutes.
I think it was fairly substantive, so I would move.
Yeah, I'm not saying it wasn't at all.
Right, so I just to get on the floor, I would move to continue the matter till the next meeting.
I'll
So that
second that.
Okay, moved by member Yankee, second by Vice Chair Yankee, second by member Highland. Members, any discussion? And this is discussion on the continuance, not on the content of the minutes. This is a procedural action. Okay, hearing none, let's open it up for public comment. Public comment on the procedural action to continue the minutes to the July meeting.
Anonymous
Point of Chair Wolf.
Yes.
Member Highland.
Yes.
Since this is procedural, is it possible to take it by acclamation and not have public comment on this?
We have to take public comment even if we take it by acclamation.
Understood. Thank you.
Yeah.
Do we have speakers?
Yes, anonymous,
Yes.
please.
Yes, please.
Speaker number 1, anonymous, you may go.
Thank you very much. One reason you may want to not continue the matter is when you continue the matter, since the minutes don't get approved until 1 month later, it also means the orders of determination can't be issued until that occurs. So 1 more month after the decision has occurred, and some city agencies won't comply with your decisions until that happens, which can be N months after the decision. If you don't decide to continue it, then you should correct one thing, which I guess I would have to tell you only if you don't decide to continue it. Thank you.
Do we have a second speaker?
I believe I am one speaker.
Mr. Warfield, you ready?
Yes,
Go ahead.
this is Peter Warfield, Executive Director excuse me, of Library Users Association. We can be reached at libraryusers2004@yahoo.com and at P.O. Box 1705, 44, San Francisco, California, 94117, excuse me, dash 0544. And I say that because I consider it important to have the same, or at least a chance at similar accessibility that one would have at a real meeting, where anybody could come up and say, liked what you said, didn't like what you say, and so on, and would like it in the minutes. I did look at the minutes, and the postponement, I think, first of all, if what Anonymous says is correct, and I don't doubt that it is, that is a very serious problem with postponing minutes. We've already talked about the problem of delays, and especially delays in anything that has to do with the actions of the Sunshine Task Force in promoting and defending open government matters for the public. So I think that is a very serious matter to consider in considering whether to do a postponement. The other thing is, there are people who have reviewed this matter and have taken the trouble to attend a meeting who may have something to say about an item that you postpone. And so their memory may fade, their availability may disappear on a second occurrence on a postponement. And so there is a correction to our address that I would like to make, which is incorrect and I think is important. It's the third time, I think, in a row that there's been some error in our contact information, which we've pointed out is important. And I would hate to miss or have to miss a meeting or have anybody else miss who has something prepared to say or has looked something over and seen something that would be improved by their contact. And so, I beg your pardon?
30 seconds.
Thank you. So that's why I would say, please consider those things carefully when you're taking into consideration whether to postpone. And I also haven't heard of doing a split where you agree with part of it and not another. Perhaps you could also approve the minutes as is or as you change them, but then make a correction next time to the portion that you know is incorrect.
Time is up, sir.
Thank you very much.
Any other public comment? Last call for public comment. Okay, public comment is closed. I will just say that, well, I understand the public comment on approving the minutes before issuing an order of determination. Let me just explain that usually in deliberative bodies and parliamentary procedure, a previous meeting is not considered to be like validated until the minutes are approved by the body. Our complaint procedure does not mention that, and I don't believe our bylaws mention that either. Let's see. Yeah, our bylaws don't mention that either. So, considering that that we are governed by Robert's Rules of Order, that in Robert's Rules, I believe, I don't have the section number, but it's generally accepted that that the previous meeting that the minutes refer to, if they're not approved by the body, then the meeting isn't validated. Now, I can, unless you want to track that down, or we can ask our legal counsel, who is here, for advice on that. We can do that if members wish to continue discussion on this. Vice Chair Yankee.
I would just note that I had worked with Cheryl actually on other items besides that one, and without knowing which version may have been sent out versus which version is being posted. I mean, I'm comfortable with the version that's posted now with the agenda, but I don't know which version she's talking about that may have gone out, and that may include other changes as well. And so my concern would be that some folks out there may be looking at one version of the meeting minutes that are quite different than what's currently posted. And so that would be my concern with approving something right now, is I don't want someone to have been looking at the wrong set of minutes and misinterpret an action that we may have taken.
Anybody else? Okay, are we ready for a vote?
Actually, it seems that,
Member Hood.
yes, thank you. It seems that I understand what happened, and that was unfortunate. As far as we know, the most up-to-date version is posted online now. If anyone read the minutes, the incorrect minutes, and I don't know, I'm having a hard time, even though I understand why we might want to slow things down, I'm having a hard time seeing if there's a logical reason why we shouldn't approve a version that is currently publicly posted.
Anybody else? Any other comments? Questions? I would only say that if the minutes are incorrect and it doesn't reflect facts or events from previous meeting, then it's kind of altering reality. If it's missing like a whole section, they're incorrect. If we approve a set of minutes that have like an incorrect vote on it, then we're approving that vote because we're approving the record of the previous meeting.
Right, and the current version of that. In any case, I said what I had to say. It seems that the version that we will vote on next month is currently live on our website.
That's right, but that only got put up today. So that means the public who's been preparing for this meeting at least 3 days ago may not have been able to see that, and there's no way to distribute it. So and wait for people to read through it, because if there's a considerable amount of adjustments, it may take people time. So I don't know how else remotely it's hard. I mean, it's probably easier remotely because everybody who's here, the question is whether everybody has internet access, and versus needing it in hard copy. So I would tend to agree to continue it. I think it is unfortunate that we would have to wait a whole month before orders of determination could be approved based upon an approved set of minutes. That's where we're
Chair
at.
Wolf, Member Highland here.
Member Highland.
I just wanted to add that, this is yet another example of our failure to provide proper minutes, properly grammatically edited. We spend way too much time correcting minutes week in, week out. I think we need to do much better as a body to get minutes right the first time, distributed correctly. So I'll just say that for the record. Thank you.
Thank you. All right, we ready for a vote? Okay, hearing no response, please call the roll. This is the motion to continue the minutes to the July meeting.
Member Yankee,
Aye.
Member Yankee, aye. Member Highland? Member Highland?
He is just here.
Come back to him. Member Fraser, absent. Member Padmanabhan?
Nay.
Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein? Member Stein?
Aye.
Member Stein, aye. Member Forsley, absent. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to continue approval of the May 5th minutes passes.
Can you announce the tally, please?
Yes. Member Padmanabhan, no. Member
Just the number. You don't have to name each person.
One no.
Cheryl?
I know, I hear you.
Okay.
1, 2, 3, 4, 5, 6. 8 in favor, 1 against.
Okay. So the motion
Motion
fails. I mean, motion passes. I'm sorry.
passes, yeah.
I was just thinking of how many we are here. It 1, 2, 3, 4, 5, 6.
9 voted.
Okay, we're 9. Okay, great. Thanks. Okay. Let's call next item.
Item number 3, file number 20067, complaint filed by Zach Karnazes against the Mayor's Office on Disability for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and/or complete manner. Complaint committee heard this case, found jurisdiction that the records published. I'm sorry.
Can all members of the public please mute your?
Yeah, you look good, girl.
Can you please mute your phone? Victor, can you please mute?
Shall I read that again?
Thank you. Yes, please.
On March 16, 2021, the complaint committee found jurisdiction that the records are public and referred the matter to the task force.
Okay, thank you. Okay, and I also to add that the committee opined that that though the petitioner received his records, it took just under a year to comply with the request. Okay, so it's a regular hearing, 5 minutes, opening statements for each party. The task force will then proceed into a question and answer period for discovery of any additional information we may need. Then there will be a 3-minute rebuttals for each party. After that, the task force will go into deliberations on the merits and then take action. So let's have the Mr. Karnazes, you first. You have 5 minutes.
Are you ready, sir? Sir, are you ready? Mr. Canazes?
Hi, someone muted me, but I'm here. I pressed *6. Can you hear me now?
Yes, we can. Are you ready to speak, sir?
Yes, and I request that please do not give me a 30-second warning. I have a digital stop clock that I will start as soon as I begin speaking.
All right. Go ahead, sir.
Thank you. Hi, my name is Zach Karnazes. Thank you again for this disability accommodation to speak at the beginning here. I filed this records request in January 31st, 2020, and as mentioned, there's no disagreement that the final records were provided in January 8th, 2021, so almost a full year later. This case is pretty clear to me, and I think a number of folks. The Sunshine Ordinance was already violated long before the COVID pandemic, the emergency orders from the mayor. The mayor's memorandum to suspend Sunshine Ordinance was issued on March 30th, 2020, nearly 2 months after my original complaint was, my original public records request was filed. And just to give some history of how hard it was and how much I had to struggle. Keep in mind, I have to use voice dictation software whenever I use the computer. It's not easy for me, and the department knows this. The Mayor's Office on Disability is there to help disabled people, to help us with access issues with our city, not make them worse. So it's especially horrible that I'm even having to be here right now fighting for our access when this department is one of the departments supposed to protect that. So I sent an email on January 31st requesting these records. I sent an email on February 4th requesting the records. Nicole Bond, the head of MOD, replied saying, please clarify if you were also looking for the materials in your inquiry to be provided directly to you. Of course I was. It's super clear in my original request. And she did that to slow me down, I think, and make it harder. And so I said again, February 6th, please provide these records. February 10th, 2020, please provide these records. February 20th, please provide these records. March 6th, please provide these records. March 11th, please provide these records. April 14th, please provide these records. April 16th, please provide these records. June 11th, please provide these records. And so on. I had to work so hard to get my own records of my own disability cases with the city. I can just quote Deborah Kaplan when she spoke at the original committee meeting for this issue on April 20th, the Sunshine Ordinance Committee meeting. She said, and I quote, the final and complete response was sent as he stated on January 8th, 2021. I also quote, he was sent records on a rolling basis on June 19th, July 22nd, November 10th, December 11th, December 18th. So by her own admission, they did not start providing records to me until June of 2020. That was at 31 minutes in of the audio recording. You can hear that in the public record from the April 20th Sunshine Ordinance meeting that happened this year. And then again at 32 minutes in, she says, quote, Deborah Kaplan says, quote, in April, we informed Mr. Karnazes that MOD was not fully staffed and was not able to gather the full materials outlined in his records request, end quote. In April, I filed the records request in January. I don't see how this can be legal, like how this even remotely complies with the Sunshine Ordinance. And again, as a reminder, the mayor's memorandum was March 30th. So I don't, I imagine they're going to try to use COVID as an excuse, but I don't see how, because they had already violated that before the emergency orders. They'd already violated that. And so it's just been a nightmare. This whole thing has been such a nightmare, trying to get my own records from a department that is supposed to help disabled people. And even if the mayor's memorandum applies, which I don't believe it does, it says, and I quote from the March 30th order, agencies still have a legal duty to provide records promptly if possible, end quote. And again, quote, agencies should make reasonable efforts to provide records to the extent feasible, end quote. Due to the failures, and MOD has not been doing much for disabled people during this time. They have not provided records for an emergency COVID meeting that happened in May 12th, 2020. In fact, those records were deleted. That's a separate complaint that I wanted to make part of this complaint, but was told that I cannot. And I'm still not even able to get the vaccine in my home, the Pfizer vaccine, because of all the access issues. Even though 75% of San Franciscans, all my able-bodied friends, are fully vaccinated, I still can't get access to the one that I need. And so, like Mayor's Office on Disability, what have you been doing during this pandemic? If you're not vaccinating people and you're not filling public records, I don't see what the excuse is. And I'm just hurt that I even have to be here today. Thank you for your time.
Thank you. Okay, Mayor's Office Disability. 5 minutes for opening statement.
Are you ready, sir, ma'am? Hello?
So you may need to press star
6.
6.
Thank you.
There you go.
Thank you. I'm Deborah Kaplan, Deputy Director of the Mayor's Office on Disability. We do not dispute Mr. Carnese's assertions about the length of time it took to get the full record. However, it sounds very dramatic to hear that it took a year for him to get the full record. Most of what he requested was provided over the summer and the fall. If you look at the timeline that we submitted in the response dated the 24th of May that we submitted to this group, you can see that Mr. Carnese started receiving records and in June and July, and one of the problems that we had was a lack of confirmation that they had been received, or a lack of response to several emails that we sent requesting confirmation or letting us know that they hadn't been received. Because of that, we weren't sure whether the records that had been provided had reached the recipient, and so we tried other methods and made them available online using the secure share system, and we also did not receive confirmation of receipt using that system as well. And so we finally resent them, and they were received in January. The beginning of 2020, during February and March, the pandemic was already starting to affect our operations, although the shelter-in-place order had not been issued yet. The reality for the Mayor's Office on Disability is that it is a very, very small office. And during February and March, 3 or 4 staff positions were not filled. And so we were operating at even lower capacity than ordinary. As it was, we would have started offering the records at that point on a rolling basis had the staff had the capacity to begin to look at the records and understand how voluminous they were. So yes, it did take a long time. However, most of the records were sent and delivered before January of 2021. They've all been received, and during most of the time, the MOD staff was working on the COVID pandemic, and staff were literally not doing their regular jobs. So that is why it took a long time, and MOD often has difficulty responding to voluminous requests like this because we do not have staff that are dedicated to responding to sunshine requests, and we need to take people away from their regular duties in order to search for records, confirm that they are the right records, and then redact them. And we will strive to do our best. Thank you.
Okay, thank you. I failed to ask for each of the parties if there's any persons or witnesses to provide any facts or evidence on behalf of the petitioner. Okay, hearing none. Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent?
No.
That's not it. Thank you. It's just meant for anyone who wishes to speak on your behalf. Okay, hearing none. Okay, members, the matter is with you. If you wish to speak, please state your name first for the record. Okay, Member Wong.
Hi, this is Member Wong. I have a question for the respondent. Looking in the packet for if there was a request for an extension due to the voluminous nature of the request, and I'm not seeing it. Does that exist in the packet, or was such a request sent to the petitioner?
We have not been advised by the mayor's office that we should be making such a request in writing. Most of us are relatively new and not that familiar with all of the processes associated with responding to sunshine requests. If we had known that, we would have requested that.
I have a quick question before Member Highland. Mr. Kornaitzis, was this a immediate disclosure request?
I'm not sure because I just learned very recently in April I'm still learning all the legalities and all the different complex stuff. So I don't actually know the answer to that. I would refer to the original request document to see if that language was used, because I used kind of a template.
Okay, because I would just say, okay, that's fine.
It was, actually, I take that back. It was because one of the things that prompted this whole thing was Heather Cattell, who was an excellent employee, Mayor's Office on Disability, and she left, unfortunately. And what prompted this original request was I needed to get my records that she had, because previously there was a city employee that was working on a case of mine, and when they left, Department of Technology deleted all their email history, their whole records. And so I originally, this was an immediate request because I wanted to make sure that Heather Cattell's emails were not going to be deleted, since she was leaving MOD. And so many of her emails had, my ADA cases talked about. So yes, it was an urgent, immediate thing that I was asking for in these records requests, if that's the question.
Well, we have a specific, the ordinance has two different ways to make a request. You can make a general request for records, and that has a particular time frame and process. And then there's an added feature which allows a person to make an immediate disclosure request, but that requires a special template. So it's important for us to know because it could change the way we make our final decision.
Okay.
All right. let's, we can, folks can, who have prepared the meeting on the task force can review the record and see if that's the case or not. We'll continue let's continue the meeting and we'll come back to that. Okay, let's have Member Highland and then Member Schmidt. Unmute, please, Member Highland. There you go.
Yes, Member Highland here. This is for the respondent. What is your record retention policy? Are you aware of what's required by law and by the Sunshine Ordinance?
Yes, we are.
Okay, and specifically for videos, how long are you required to keep those?
I couldn't tell you off the top of my head. I would have to look and see. The video in question was not under the control of MOD.
Okay, the answer is permanently, just so you know. But okay, I logged your response. That's all I have.
Okay, Member Schmidt.
Yeah, question for the respondent. Probably a couple questions. The language you used in your presentation, you said that the people who eventually responded to this request, they had to go outside of their regular duties to do so. Who were those people?
Iman Al-Ghazari, who handles 88 complaints for the office.
Okay. Do you have anyone who considers this to be within the scope of their regular duties to answer public records requests?
I mean, it would be probably under, we have one administrative support person, and we assigned it to Iman because she was familiar with the records. And I'm trying to remember at that period of time, Iman was brand new and first had to acquaint herself with the Sunshine Ordinance requirements and what our processes are. But I guess I would say it's not their primary responsibility. It is a responsibility, but there's nobody on staff who does mostly responding to Sunshine requests because we don't get that many. And as opposed to large offices that have people who, that's a significant part of their job. That's pretty much what I meant. I was mostly explaining our capacity due to the size of our office. When we're fully staffed, we have 7 or 8 employees, several of whom do architectural reviews, and the regular staff who don't do the architectural work are 4, and we were down to 2 when this request came in, including our director.
It sounds like you are now saying that you would prefer the language primary duties to regular duties in assessing this. Now, who in your office would be on primary duty to respond to these? Anyone?
It would go to 1 of 2 people.
Okay, and what's a primary duty and what's not a primary duty? Is there some definition that you can give me?
Sure. The primary duties are listed in their position descriptions, and it's what they spend most of their time doing.
Okay, so you have position descriptions for everyone in the office, And then you're saying that there's one or two people who have this duty as a primary duty within their position description, correct?
No, as
No.
this would not be a primary duty.
It's not a primary duty.
This would be a duty that they are required to do when necessary.
Okay, no further questions.
Okay. Members, any other questions, clarifications? Okay, I have a couple more questions. Mr. Kornatzitz, am I pronouncing your name correctly? Kornatzitz?
Yes, yes.
Okay. I see your original request to the Mayor's Office of Disability on January 31st. When did you get your first response from them? What date was that?
I was trying to find that today, and the thing is, I didn't get any really clear response. I would check with MOD because there's so many emails and it's so hard to access them, but I think it was sometime in March. I did get a reply from Nicole Bond, the head of MOD, as I mentioned before, on February 4th, but it was this really weird reply that was like, please clarify. It says, quote, please clarify if you were also looking for the materials in your inquiry to be provided directly to you. I don't know if I can count that as a reply because of course, it's a public records request. It's labeled as such. It's like in a legal template. Like, as far as an actual substantive reply of like, we need more time or, anything like that, I don't even think it was until April. Like, it was a very long time. And so, yeah, I think the questions that the members are asking are really valid because if things would be very different if I'd gotten an email in February that said, hey, we're really busy right now. We're going to fill this request. We just need some more time, rather than being ignored and having to write, a dozen plus emails repeating the same question over and over again.
Are you talking about April 2020 or April 2021?
I'm sorry. All the dates I'm referring to right now are 2020.
Okay, thank you. Members, any other? I have I have a question for Ms. Kaplan. You mentioned that that you were providing information on a rolling basis. It's kind of triggering me a little bit because that usually comes with an immediate disclosure request. It's usually not, unless it's agreed to by the parties, it's usually not something that would be initiated for a standard request. So
I guess then I would have a question, which is when a very small office such as MOD gets a request for literally hundreds of documents that must be found and identified and then confirmed by somebody who is familiar with the records and then redacted, which would take, to do so if somebody were working full-time on nothing but that, would take longer than the time frame given what is an office supposed to do. And during this time, our staff were deployed as disaster service workers and not available at all. So it's unclear to me how we're supposed to respond and get it done within the time frame when it's very, very voluminous.
yeah, okay, I understand. Thank you.
I would also just like to add one other thing. A review of our record shows that MOD provided confirmation to Mr. Carnese that his records were not subject to deletion or removal, and that email records from the previous MOD staff member, Heather Kittle, were retained. And those records were part of the search that we did for records that were requested.
Okay, thank you very much. Member Highland.
Yeah, just a question for the plaintiff. It sounds like, or was there a list compiled of everything you asked for and everything that was given? Is there an index that you kept or they kept? What I'm trying to get to is, what are you still missing, if anything? Perhaps you can answer that.
Sure. I don't think there's any dispute on whether or not the records have been provided at this point. As far as I'm concerned, everything was provided by January 8th of 2021. I think there is some dispute on this rolling basis question and how many records were provided in June and July, and the accessibility of this this portal that MOD put the records in the fall of 2020, which was an issue, and the issue of whether or not I responded to confirm records being received, that kind of stuff. There's some disagreements I have, but as far as the actual records being received, I don't dispute that. I believe everything was received on or about January 8th, 2021.
Okay, thank you.
Okay, Vice Chair Yankee.
Yes, a question for the respondent. Can you maybe explain what took your department such an extended period of time to get these records together? Was it trying to locate them, or was it a redaction process? It sounds like there was a voluminous request, but at the same time, it sounds like there was still a year that went by, and so maybe you can help to explain what was the biggest hurdle that you folks went through when trying to get these records over to the petitioner.
Probably searching for them and finding them. I know that Ms. Alzagari had to literally look through and open hundreds, if not thousands, of emails in order to find the appropriate ones. And then we spent also at least 2 or 3 hours with her questions about what needed to be redacted and what shouldn't be redacted. I know she spent 2 or 3 days a week in the summer and in the fall working on this.
And just as a follow-up to that, were these all electronic records that if your staff was working remotely, they could access? Or were any of them hard copy records that you did not have access to because of various building closures and such?
They were all electronic.
Okay, thank you.
Member Neighbors.
It seems like to me that what is maybe kind of new and unknown territory for Ms. Kaplan and the staff of the Mayor's Office on Disability is in some ways really routine to us, right?
Okay. Member Neighbors, I'm going to interrupt you because this isn't the period where we're deliberating. So if you have any questions, this is discovery.
Okay, so I was going to ask them, before this request, then Ms. Kaplan, what kind of preparation or exposure had you had to the Sunshine Ordinance?
Myself.
Your office.
Our office had plenty. However, Nicole Bond was on detail or deployed during most of it, and so she was not able to give much guidance and both Ms. Algazari and I were learning as we were going.
Thank you.
Okay, we have member Padmanabhan and then member LaHood.
So this question is for Mr. Karnazes. What did you receive on June 19th and July 22nd then?
I'm afraid I don't have immediate access to that right now. I don't know off the top of my head. I think Mayor's Office on Disability might have more information to answer that question.
Okay, so that could I ask the respondent?
Absolutely. Go ahead.
I believe it was several files that were in a zip folder of emails and attached documents.
They were directly responding to the records request?
Yes.
Okay, thank you.
Okay, we have member LaHood.
Yes, Ms. Kaplan, you mentioned the pandemic and the emergency order, which came at the end of March. This original request came in on January 31st, 2020. So there was a period of 2 months. Can you describe what was done in that 2-month period? And I know you said that there were concerns about the pandemic that your department was involved in addressing, but can you tell us what was done in that 2-month period?
I know that Ms. Alzagari began to become familiar with the Sunshine Ordinance and the procedures used by our office. And I do know that it languished for a while, partly because she was unfamiliar with the timeframes that were required. Once she elevated the issue, we began to prioritize it. However, by then it was March, and our office was already very involved in advising public health and other parts of the city about reaching people with disabilities and thinking through the impact of a potential shutdown on people with disabilities.
Thank you.
I have another question for Mr. Karnazes. I'm reading in our file, starting with page 263, and that would be PDF page 11. It starts out with one request dated January 31st. That has a significant list of items for email history. And then there's on page 266, PDF page 14, you have a second request on the same date, also to the Mayor's Office on Disability, for all grievances filed. And then you have a third request, same date, January 31st, 2020, on page 268, PDF page 16, for a list of meeting dates that you attended and minutes, notes, and video links for meeting dates requested between December 2016 and January 31st, 2020. Are you saying you did not receive any of these records within, let's say, a month by the end of February?
Yes, that is absolutely correct. According to my records, I did not receive a single record from this department for anything until sometime in June of that year. So nearly 5 months, 4 or 5 months later.
Okay, great. Thank you. Okay, member, any last questions? Should we move to rebuttals? Okay. Ms. Kaplan, you have 3 minutes for rebuttal.
Ms. Kaplan, are you ready? Ms.
Yes,
Kaplan? Okay,
yes, I'm here.
go ahead. Go ahead.
I guess I would simply like to point out that Iman Al-Zaghari had just started her work. And in part, that was apparently what prompted Mr. Carnese to be concerned about the retention of his records. She was brand new and unfamiliar with the importance of a request of this nature. It wasn't elevated to the appropriate parties in our office until, I'm not positive, the end of February or beginning of March. And it definitely, under the ways that we are operating now, I mean, I would have to say, because of the hearing and preparing and doing the work of responding to this request, all members of our staff are now fully cognizant of what is required and understand the importance of responding to requests of this nature in a timely fashion. We still do have problems with providing materials when the request is very, very voluminous and requires searching through large numbers of files, like email files, just to identify what needs to be looked at. However, we understand, and it definitely was an error on the part of MOD that the documents were not provided, and we didn't begin the process of going through them, identifying them, and at least providing what we could earlier. And we would welcome guidance about what is possible for a very small office to respond to large volume requests. What we've been told by the mayor's office is that we can respond by saying we have to do this on a rolling basis because we don't have the capacity of getting everything done within the time frames that are ordinarily envisioned. And I guess I would simply like to point out it's not a ruse and it's not an excuse that MOD has been and continues to be very involved in working on the pandemic and working on now pandemic recovery. And so it's been an unusual year. Thank you.
Thank you. Mr. Knatzis, you have 3 minutes for rebuttal.
Hang on a second. Mr. Karnazes, are you ready?
Yeah.
Go ahead.
Hi, thank you. You know, it's nice to hear, but also sad that here we are a year and 4 or 5 months later to finally hear MOD admit any responsibility for this debacle. And the only reason they have is because I've been fighting so hard for so long to bring this complaint to the Sunshine Ordinance, which I never wanted to do in the first place. It really sucks to be here as a disabled person, trying to hold the Department on Disability accountable for a very basic thing. Deborah Kaplan, you can hear in her responses today, her evasiveness. She won't even disclose the 2 people that are responsible for public records requests, even though The questions answered were very fair. Who are the people that answer those records? I still don't know. Do I have to open a public records request to find out who answers public records requests? I mean, the answers with this department are routinely evasive. And I think they figured they could ignore me and just ignore this issue. And they did for months and months and months. I addressed this issue to Nicole Bond directly, who's the head of MOD, who's very familiar with these issues. And she responded in February, on February 4th, saying like, are you sure that you want these records? And I said, yes. And for the whole month of February, did nothing. And so I just don't buy this whole, we're a small department, we're a small department, we're a small department. Deborah Kaplan has said that 4 or 5 times now today. And it's not an excuse. Like they could have reached out to Sunshine. They could have reached out to other government entities that have more experience with processing records. And they could stop doing what they routinely do, which is ignore disabled people that have real needs. And, they keep citing the pandemic. Their response to this pandemic has been atrocious. 7 months of mayor's office of mayor's disability council meetings were canceled during the course of the pandemic. So the disabled public could not bring pandemic issues to them directly in a public setting. That was horrible. So like they canceled all the meetings. They didn't get people the vaccine. What are they doing that's keeping them so busy that they can't fill public records requests? I don't understand. I still, I don't want to bring that into this because I feel like that's a separate issue. But when she keeps mentioning, we were busy with the pandemic, it's like doing what? I mean, I don't know. I don't understand. And again, not a single record was provided until June. I mentioned how many emails I had to send just to get a basic response. And so I was ignored. I mean, I was clearly ignored. And MOD, I think, just figured I would go away. They wouldn't have to deal with this. No one's there to hold them accountable. Disabled people are too sick to do anything. And most of the time I am as well. But this was one I wasn't going to let go.
Wrap it up.
It's really not okay. I'm at 2 minutes and 45 seconds. Thank you. Okay. And so I have 3 minutes, right? I appreciate your time here today. And, I think this department really has a long way to go and really needs to do a lot of things differently. Thank you.
Thank you. Okay, members, now it's time to deliberate on the merits and take action. I'd like to recognize Member Forsley at 5:20. Okay, I'll start the ball rolling here on our records page 316, PDF page 64. You'll see the beginning of the email thread, which accounts for Mr. Karnetz's multiple times that he's tried to contact them. Not going to go through it, but if you read up from that, you'll see at least the first one at the bottom of page 316. A person from Mayor's Office of Disability, Heather Cattell, responded that she no longer works there. That may be an auto reply. Nonetheless, immediately thereafter, Mr. Karnetzis had contacted both the Department of Technology and our office that he was concerned that the records may be deleted since that staffer, may be leaving. Let's see, contacted us again on February 3rd. And then he gets on February 4th, receives, so that is 4 days later, receives a message from the director of the Mayor's Office of Housing, Nicole Bond. That's on page 315. And basically states their retention policy, and if and requesting some clarification. So you can follow that scrolling up. I will say that this is a regular public records request under 6721. Mr. Kurnetz has made the request under CPRA 6250, section 6250 at sequitur, meaning the entire CPRA, under the entire CPRA. CPRA does not contain an immediate disclosure request. That is an enhancement of the Sunshine Ordinance that is allowed by the CPRA under state law. So we'll be focusing on 6721 for this file. Sorry, I'm not watching the, yeah, okay, Member Schmidt, then Member LaHood.
Yeah, I am actually interested in asking a question of our legal counsel. Is that okay with you, Chair?
Yep, absolutely.
Okay. I don't know if this is the case where this question is a prime question, but I think we probably are going to, be seeing this situation often where someone makes a request and the volume of what they request is significant. And, the agency might need to spend a lot of man hours or person hours responding to it. And my question to legal counsel is there a sort of a line? Is there a point where, the law says that the agency is allowed to extend their time, they're allowed to object? Is there a sort of a burdensomeness standard as you would have in a civil litigation? Or in these kind of cases, is that never going to be an issue? And do we just expect, which, I generally expect it, but that the agency be responsive and act immediately to respond? Any thoughts on that, legal counsel?
I know DCA Price Wolf is here in the meeting. You'd have to press *6 to unmute yourself. I don't know if DCA Castillo is here. Don't see her listed.
And I can certainly save the question because I don't know if it would affect my vote in this case. Okay. But I feel this like, oh, there we go.
Here he is. Go ahead.
Okay.
Hello.
Yeah, go ahead.
Sorry. Can you repeat that? Do you mind?
Okay. I'll try to state it better. But I'm wondering, in this kind of case where you're talking about thousands of documents or thousands of pages of documents that are requested, and there is a claim that, that there were so many hours needed to respond, to filter, etc. What would the threshold be, if there is one, where the request is so massive that the agency just has to say, look, we get relief here, we can take more time, it's too burdensome? Because the standards they're not clear, and there's sort of like a language here and there that might apply. Do you have any thoughts on that?
Yeah, no, that's a great question. And, you know, I haven't dug into this area of the law in a little bit, but the last time I did, I think your instinct is spot on. Like, it's just fuzzy. There's not really case law where this direct issue has been brought up. In other words, where someone has sued a local agency when they have invoked the excuse or the justification that it's just overly burdensome, and then they won, you know. So there hasn't been a real bright line drawn by a court. My sense is that this justification is used for when there's a public records request that says, you know, hey, department, please give me every single record you have. Hey, department, please give me every single record you have related to water. You know, something that is just like, that's just impossible. But otherwise, I think the expectation is, if you can wrap your brain around it, just take your time and get it done. Maybe it's only, you know, if the agency only has 3 people, and really, you know, the agency will not be able to function on its core mission by allowing more than 2 or 3 hours a week to fulfill this request, then it's going to have to take 40 weeks because that's all the agency can really devote, right? I think it's okay if you can explain it and it's reasonable to this body and just to reasonable people. I think that makes sense. So it's a sliding scale type answer where you don't want a public records request to eviscerate an agency's ability to work their core mission. And I'm not saying responding to public records is not important, but I think like it's also reasonable for the agency to turn around and say, okay, this is our plan. We're going to devote X number of hours a week. And if they can really show legitimately that they are doing that, I think that's reasonable. What I think is unreasonable is saying, well, this just feels too big. We're just not even going to do it. When in fact, you know, they could do it, but it would just take a really long time. You know what I mean? I think it's much the latter approach.
So, yeah, I'm hearing some kind of a sense of a reasonableness standard.
Yeah.
And can you give me anything that's in a legal provision that would support, you know, applying that type of analysis as to what's reasonable, what's not, you know, are we over the line, not over the line, anything in terms of citations?
You mean you just don't want to cite me? That's not going to carry the day.
Well,
yeah, let me look at
okay,
something.
There we go.
Now give me 2 minutes. I have a good idea where I could look to find something.
Okay,
Can I make a clarifying point? I think there's some.
No, Mr. Kranatsis,
Okay.
your period of time for comment is over. This is now with if somebody on the task force wishes to get further clarification, they can ask, but the item is now before us. Okay, let's, if you need a little time, DCA Wolf, then let's move to Member LaHood.
Thank you. Yes, I had a question. So obviously 6721 for timeliness makes sense. I'm wondering, would we also be looking at, and I just lost my notes, 6725D, which does allow for rolling, but the idea is that you're not supposed to wait until you have everything. And it seems that even though records were ultimately provided on a rolling basis, the rolling started several months late. And I understand that there was confusion about what was required, but it seems to me that there's a violation here, that the delivering of what could have been delivered earlier should have happened, even if it was going to take longer to deliver some of the records.
Let's be clear that there is a distinction between 6721 and 6725. Okay, the rolling basis that you're identifying in 6725 referring to is only specific to immediate disclosure request.
And I see, and it was, even though it was urgent, it was not labeled as an IDR.
And it wasn't even requested under the Sunshine Ordinance. It was requested under the California Public Records Act.
Okay.
And then he filed a complaint with the Sunshine Ordinance under the CPRA. So, I mean, the CPRA is, doesn't even speak to rolling. It requests, it basically makes a mandate that it has to be provided within a period of time. Now, under 6721, we have two areas that provide timeframes. In subparagraph B, it states that if the custodian believes the record or information requested is not a public record or is exempt, the custodian shall justify the withholding of any record by demonstrating in writing as soon as possible and within 10 days following the receipt of the request that the record in question is exempt under express provisions of this ordinance. And then in subparagraph B, so subparagraph B specifically referring to items that are exempt or that can be withheld. Subparagraph C is speaking about items that can be disclosed, and states that a custodian of public record shall assist the requester on identifying the existence, form, and nature of any records or information maintained by, available to, or in the custody of the custodian, whether or not the contents of those records are exempt from disclosure, and shall, when requested to do so, provide in writing within 7 days following the receipt of a record, a statement as to the existence, quantity, form, and nature of records related to a particular subject or question or questions with enough specificity to enable a requester to identify records in order to make a request under subparagraph B. Okay. Further, the last sentence is a custodian of any public record, when not in possession of a record requested, shall assist a requester in directing a request to the proper office or staff person. So even just a response within, within a week saying, we have these records, we know they exist. Here's where we think they are, and even at that point saying, this is such a large request, a voluminous request, as member DCA Wolf was saying, here's a schedule of how we're going to make this happen for you. And it basically becomes just the negotiation between the parties at that point to do that. That's why subparagraph C is written the way it is. There's an expectation that it be that the record be produced or disclosed within 10 days. So I would kind of refer to those sections. That's what I'm looking at here. I know we're for this, the response was way beyond. And on page 313, PDF page 61, you'll see on February 20th, Mr. Karnatzis writes to Iman Al-Zagari and to Director Bond that he's not received a reply in 16 days. So, and then it just keeps going on from there with Mr. Karnatzis continuing to get a response. And then finally on April 14th, he does receive a response from Director Bond asking for clarification on so that's there, basically stating that, the the records are being retained and filed.
I'm not sure which number this is.
And then if there is that's on page 310 or PDF page 58. That's April 14th. That was after Mr. Knatzis had made another request on March 11th, stating it's been 35 days, and then over a month later, he makes another request on another inquiry on April 14th, and then finally gets a response on April 14th. You know, he's basically asking if there's a specific correspondent that he's looking for. His original request is well stated on three separate documents. So this is after the shelter-in-place order was made, but you know, almost 2 whole months went by. Okay. Any other discussion on this? Formulating an action. Is there a motion?
Sorry to break the silence without a motion, but I found two cases, Member Schmidt, that I'm just going to send you the citations. One is in the context of like someone making tax records requests, and another is in the context of someone making a public records request for grand jury transcripts. And the California appellate courts have said, look, there is an implied sort of common law rule of reason that we balance our requests against. It's about as far as the cases go in describing it. You know, absent limiting statutes, I think it's okay. So I'm going to send those cites to in a group text right now, but I found those two cases that are where the implied quote unquote rule of reason is applied in the public records context.
Thank you. That's extremely helpful, and I don't think it would affect my thinking on this case, but I'm seeing this more and more, sure. And I'd like to. Those are something new to me, and I feel like I'm kind of at sea as to what are the outer limits here. So appreciate that. Good.
I will say that the task force has received over the years a number of responses from respondents citing the rule of reason, and we've had to grapple on how to manage a response like that. What we have been doing is requesting or asking or demanding that the respondent make specific as to why they're citing the rule of reason, and to show evidence of why that they feel that this citing the rule of reason is appropriate, and we should take it into consideration. Considering that there are no guidelines or there is no law, it really becomes somewhat arbitrary, and then we would, in our wisdom and collective wisdom, can deliberate as to what that could or should be on a case-by-case basis. Member Wong.
I'd like to make a motion.
Go ahead.
So I'd like to find a violation of the Sunshine Ordinance Section 6721 for failing to respond to public records requests in a timely manner. And this is found against the Mayor's Office on Disability.
I'll second that, Member Highland.
Okay, it's moved by Member Wong, second by Member Highland, to find a violation of 6721 for failing to respond to a request in a timely manner against the Mayor's Office of disability. Okay, discussion. Any discussion? Okay, let's open it up for public comment.
Anonymous,
Ms.
please.
Leger, Ms. Leger, when you're ready, handing it over to you.
Do we have, how many speakers do we have?
I'm one, anonymous.
Okay.
Are
Do
you
we have-
asking for public commenters?
Yes, I just want to know how many there are so I can keep track.
Well, I'm one. Thank you.
Okay, anonymous is one. Do we have a third?
Everyone's just on the meeting?
I'm sorry?
They don't have to raise your hand thing. People literally can talk during the meeting. Like in public, can like chime in.
This is a public comment.
Hello, is somebody there wishing to make public comment? If you're not going to be making public comment, please mute yourself. There's a lot of background noise. Please press *6 to mute yourself. It toggles back and forth. *6.
Thank you, Chairman.
Am I allowed to make a comment as a plaintiff or no?
No.
Okay, thanks.
Mr. Warfield, are you ready?
Actually,
I think
anonymous
was first.
Okay.
Hold on, before you start, could whoever's on the phone with a number ending in 0633, please mute themselves?
I believe that's the plaintiff.
Is that you, Mr. Krenetsis?
No, that's
There
not
you
me.
go.
I'm muted.
Okay, great. Thank you. Thank you, caller. Thank you. Okay, go ahead, Ms. Leger.
Anonymous, you may begin.
Yes, thank you very much. So there's a few points here. I actually agree with Member LaHood. This is a violation of the rolling response requirement because 6725D does not require or rely on 6725A or B. I don't believe you have to have an immediate disclosure request. But regardless of that, there's an additional violation here of a very specific timeline, and that is CPRA Government Code 6253C, wherein the respondent had to provide within 10 days a notice of determination of whether there were disclosable public records or an extension of 14 days up to a total of 24 days. And that's a very specific timeline that has nothing to do with the rule of reason or volume. You just have to tell them, are there records? What are the reasons you might not be providing them, etc. And that is CPRA Government Code 6253C. Now, finally, the rule of reason is absolutely a real thing. It does apply even in San Francisco, and I'm just going to read what it applies to because it definitely doesn't apply here. And that is, the right to inspect is constrained by an implied rule of reason to protect records against theft, mutilation, or accidental damage, prevent interference with the orderly functioning of the office, and generally avoid chaos in record archives. And that's from 2 court cases and 1 Attorney General opinion. And they should still have provided within 24 days at the maximum the notice of determination of disclosable public records and explanation, the schedule, whatever you want to call it. But they should have never started to give the first rolling response months later, and that's admitted even in their own response. So yes, you should have this motion, but you should add a violation of 6253C, which has very specific timelines about a 10-day response and with a 24-day maximum extension. Thank you.
Next speaker, please.
Please let me know when to begin.
Okay. You may begin.
Thank you. This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com. Also, P.O. Box 170544, San Francisco, California, 94117-0544. With respect to the comment of Anonymous, I completely agree. I was going to be a little more non-specific about the exact citation. because CPRA does require that, excuse me, that there be a response within 10 days as to whether the records are public. They're not supposed to just leave you hanging and wondering what happened. Did I drop this into a bottomless, literally bottomless pit? There goes my timer, so I guess I'll get a thank you for the 30-second warning. And as Anonymous said, there's then a further extension possible, but a deadline imposed. There were a number of things that I found troubling with respect to the testimony of the respondent, and that didn't seem to be fully taking responsibility or accountability. First of all, I thought that a lot of people are working from home, and I don't know how that would affect the ability of the staff to function. It might slow things down, but with technology, it seems as though even working from home, that it would be possible to do quite a lot. And to keep in touch with the, certainly as required by law, to keep in touch with the requester. I think the mayor said, the mayor's office said something about this being possibly a dramatic complaint. Yeah, it's dramatic when somebody has to wait a year. And I would be even more dramatic. I'd say it's not so dramatic. I would say people could die before getting what they're entitled to, especially under COVID. There was also a statement about taking people away from their regular duties. I think Member Schmidt was questioning that. I can't cite exactly where it appears, but I'm clear on it appearing at least in the voter handbook, and that is that responding to records is supposed to be a part of anybody's job, anybody in government, and it is not something separate or apart or secondary. And then there was stated that we made an error. Well, it was an error. It was also a violation of the law. That's a little more serious. The attorney talked about the core mission and 2 hours a week. Again, I think that core mission includes responding to records requests. So I agree with the motion. Thank you, and we support it. Thank you.
Any other public comment? If you wish to speak in public comment, please unmute yourself by pressing *6. Okay, hearing no public comment is closed. I have a couple of questions here. One is for our administrator. The agenda and the complaint summary both reference 6721. Was that brought to you by the complainant?
I believe it was.
Okay.
I don't think it was an IDR. I thought it was just a basic request.
No, but did you come up with 6721, or did the complainant mention or specify 6721?
I haven't looked at the records recently, but if that's what the petitioner requested, I would have put that in there.
Okay, only because the complaint form that he used didn't specify. It just said alleged violation, public records, and public meeting.
Yeah, I probably said 6721.
Chair Wolf, this is Victor Young.
Yes.
Generally, if they just give us a general descriptions, we write in whatever sunshine ordinance most likely applies. And we do that, if it's not specific as to what code they're filing under, we pick the relevant sunshine code on our own.
Okay, because under the request that they had made, their request was under the CPRA 6250. So I'm going to redirect my question then to DCA Price Wolf. When the request is made under the CPRA, but a complaint is being brought to the task force without specifying a particular site, a particular body of law, whether it's a CPRA on its own, or the Sunshine Ordinance, something specific to or unique of the Sunshine Ordinance, how should we be considering it?
So, I mean, that's a really interesting question because on the one hand, I don't think the complainant should be penalized if they, don't know every citation out there, but they feel like they're unhappy with the response that they received, and they can articulate what the problem is, but they might not have put the right citation. And then through the discovery process and going back and forth, you realize actually there's three big problems here, but since the complainant didn't put down the right one, we're only going to focus on one, right? But I think the right approach is, to the extent that you guys have identified the right statutes at hand, as long as both sides feel like they have had adequate time to address those issues, I think it's fine if it wasn't originally brought up by the complainant or respondent. So in other words, like, as long as the respondent isn't feeling surprised or didn't have an opportunity to address these issues that are coming up, I don't think you're restricted from talking about other violations that you might be seeing or that are in the record.
Okay, that's a good response. Thank you. You just triggered another thought for me, in that it's the Sunshine Ordinance is applicable to the city and county of San Francisco. So the operative procedures should be with the ordinance, despite a request citing the California Public Records Act, because what's active here by extension is the ordinance. And I would generally think that the provisions by that extension are it should be just applied in general by the city and county, whether or not the request was made under the CPRA or under Sunshine. Does that sound right?
Yeah.
Okay, great. Thank you. All right, anybody else? Okay, Member LaHood.
Yeah. So given that we're not limited to only considering what the petitioner mentioned, is the citation I brought up earlier relevant, or do you still think it only applies to IDRs, even though it seems unclear? But I mean, I'm just bringing it up in case you want to include it, but if you don't want to, I think there's enough, obviously, to find a violation under 6721. So
I have a response to that, but I'll let others speak up first if they have thoughts. No one? Okay. My response to it is 6725 was a deliberate section created by the framers. And what's inclusive, if there's a subparagraph of that, I believe in constitutional construction that it's got to be applicable. I mean, we deliberated this with regards to Prop B for the Privacy Act, allowing the Board of Supervisors to make to amend the Sunshine Ordinance. We found it to be that the any changes to the Sunshine Ordinance that could be made by the Board of Supervisors should be specific to the Privacy Act, because that's what was inclusive of the ballot measure, and we are kind of subject to a single subject type of rule here in the city. When you make motions, it should be about that one particular subject. If you've got another subject that's coming in, there should be a second motion, but not contain, no kitchen sink, like omnibus type of actions. So I contend that subparagraph D is applicable everywhere in the Sunshine Ordinance. Otherwise, it would have been repeated in 6721, and it's not there. So it may be an interesting thing for an amendment, a future amendment. But that's the way I read it. You know, others may.
Wait, so to clarify, you said you think it's applicable everywhere?
No, I'm saying it's not applicable.
Oh, not. Thank you. Okay.
It's specific to immediacy of response under 6725, starting with A. B it talks about voluminous nature of information requested, but that's in relation to A. It's all in sequence, and that's the way 6721 is written itself. 6721 could be seen as actually a guide in order of how a request is to be made. And so, you know, I would say that it's 6725D is not applicable under a 6721 violation. That's just my thought. Others may have may want to argue against that. Okay, anything else, members? Are we ready for a vote?
I think Member Stein had something to say if
Yeah,
it was muted.
I was just going to say I would also be more comfortable just leaving it with 6721 because I also read 6725 as just being about immediate disclosure requests, and none of the complainant's requests or none of the petitioner's requests were identified as immediate disclosure requests.
Okay. Vice Chair Yankee.
Yeah, not related to that particular topic, but just, you know, I don't know if we want to consider possibly referencing Government Code 6253C, which kind of supplements, I suppose, what's in 6721 of the admin code, but it also ties in the CPRA as well. I don't know if anyone has any thoughts about that.
I would just ask, does it create any conflicts or misunderstandings about how the ordinance is an enhancement if it changes the time frame?
I mean, to me, I would think that my reading of 6721B and C would essentially, you know, if those were fulfilled, then 6253C would have been also fulfilled. So I'm not sure it's necessarily required that we include it in this situation, but seeing as how there was also an initial request made under the DPRA, maybe it's worthwhile to throw it in there as well. I'm not sure they conflict, but I could see certainly a violation of both simultaneously.
But is it in our authority to be supervising the CPRA?
Absolutely.
It is?
Yes. CPRA, the Brown Act, and the Sunshine Ordinance.
Okay.
So I'll, unless you want to make, do you want to make an amendment to the motion? Vice Chair Yankee?
I don't necessarily feel that strongly about it, since I think Member Hood's initial motion, you know, sums up as well, but I didn't know if we wanted to. Or, I'm sorry, was it Member Wong's?
I didn't make a motion.
Wong.
Oh, I'm sorry. My mistake.
It's okay.
It was a while ago. Member Wong's initial motion. But I just wanted to throw out there. I'm fine not discussing it further though.
Okay. All right. Any last words? I'm ready to move this vote. Okay. Please call the roll, Ms. Leger.
Member Wong?
Aye.
Member Wong, aye. Member Highland?
Aye.
Member Highland, aye. Member Frazier, absent. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to find a violation of 6721 for failing to respond to a public records request in a timely manner has passed.
And the tally was 10-0. I will also direct the Complaints and Amendments Committee to monitor this item and report back if there are any issues to the task force in July.
Chair Wolf, by monitor, could you clarify that?
Well,
Just so
it's their charge to monitor. That's in our bylaws. They regularly do. They'll,
I'm just trying to get it for the record. What are they? What is the goal of the monitoring, just for our record-keeping purposes? Just so members of the public know.
Everything was received.
Yeah, that the records that were requested are received and that our order of determination is complied with.
Thank you very much.
Thank you. Okay, since we're past our 5 o'clock hour, we're going to go to public comment. So please call that item.
Second. Item number 4, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Okay, members of the public, this is your opportunity to address the Sunshine Ordinance Task Force on any item not on today's agenda. Ms. Leger, I will hand the clock over to you.
Do we have speakers?
Sure, I'm one, anonymous.
Anonymous?
Yes,
okay.
please.
Mr. Warfield, you're number 2. Do we have other speakers?
Zach Carnazes, number 2.
Okay, number 3, Mr. Carnazes.
And can you please press *6 for anyone on the line for accessibility purposes? That's how you speak right now.
You press *6 if you wish to speak. If you're not speaking, please press *6 to mute yourself. Okay. Okay. Anonymous, you're first. Go ahead, sir.
Hello, may I begin?
Yes, yes.
Oh, okay. Thank you very much. So first, I would ask that the task force, not with regards to the previous complaint, but in general, consider what its position on 6725 is, because the restriction in Section C, where they can't ask you for your intent, I don't think should apply only to immediate disclosure requests, and I don't see why that would be the interpretation. 6725A and B are about immediate disclosure requests. 6725D is not a subsection of 6725A or B, neither is 6725C. And I would hope that the protection of not having to ask for the intent of your request applies to all requests. And I think it would actually make more sense when you have a voluminous request that is not an immediate disclosure request. It might actually be a bad incentive to say the city can only do rolling responses for immediate disclosure requests. So I'd ask you to consider that, what the task force thinks about it. I'd also ask the task force to schedule, whenever it can, Mr. Hooper's long-standing Green Benefit District complaints against OEWD and DPW. He has waited 2 years. Member Schmidt had already identified a solid violation against at least OEWD at your December full task force hearing. I don't think it's right that Mr. Hooper has to still give more lists and whatnot. There's solid proof, not only what Member Schmidt's legal argument was in December, but also because I found additional records that are exactly about that financial paper trail. They were dated before his request, and they did not provide those records. And they gave them to me, so they're not hiding it anymore. But you should schedule that, and Mr. Hooper deserves. He doesn't need to find all the violations. If you can find any violation, that should be good enough to issue an order against OEWD and force them to redo the search, including the way Member Schmidt discussed regarding contractors. Thank you very much.
Mr. Warfield, are you ready?
Yes, let me know when to begin, please.
Go ahead, sir.
Thank you. This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and also at P.O. Box 170544, San Francisco, California 94117-0544. First of all, I'd like to second what the anonymous caller has said with regard to rolling requests. I'd also like to maybe expand it somewhat. And that is, it seems to me a business-like way of doing business would be to have contact with the person making the request so that they don't have a wall of silence as the minimum response from the agency. I know that at one point, Library Users Association started making pretty much every request an immediate disclosure request of one particular agency, because if we didn't, we wouldn't have a clue what was happening until the maximum time elapsed would happen, which would be 10 days, and then maybe we would get a response. With an immediate disclosure request, at least we would know that they got the request and that they acknowledged receiving the request and that presumably they're either satisfying it or working on it. And I think that somewhere, if that isn't in the law already, then certainly, well, what Anonymous said is in the law, but perhaps there needs to be more, especially with long delays. It just seems to me a decent business practice. There was a mention, and I was glad of hearing about it, with regard to unapproved minutes. And one of the things that I've been puzzled about was that the first meeting in recent times that we attended, there hadn't been a meeting of that body that Mr. Highland chairs, and I can't think of the name of it, hadn't met for just a few months, less than 2 years. And there was an unapproved minutes in there, which seemed to me ought to have been approved if it hadn't, in the full task force, under the bylaws, if it hadn't been approved within 6 months. And then fairly recently, the task force was approving a committee meeting agenda minutes, that was way under 6 months, and I think even less than a month. So that led to my asking a question at that meeting, and I appreciate very much Member Yankee answering, but it was a bit of a sort of a partial answer that he cited the rule, but perhaps I didn't explain more clearly why I was raising the question. In other words, in one case, 2 years, minutes were sitting without approval. In another case, less than a month. And it's particularly painful, I can say, for our purpose, because there have been minutes that have specifically said things incorrectly, and in particular have undermined our wish to have our contact information in the minutes, and have placed what little they have put incorrectly. Thank you.
We have another speaker.
Yes.
Are you ready?
Yes. Please let me speak without interruption, though. I have a stopwatch that I'll be using.
Go ahead.
Hi, this is Zach Carnazes. Thanks everyone for your efforts. It's been a very long meeting already, but I really appreciate everyone's thoroughness here. I have some concern with what seems to be a pretty high bar that members of the public, especially disabled members of the public, need to know to file complaints with this office, especially in regards to like these really specific citations and California citations and local citations. And I just really worry because, you know, when I file public records requests, I say urgent, I'm disabled, I need help filling this out. Can anyone help me? You know, ironically, the mayor's office on disability is the department that's supposed to help disabled people, as far as I understand it, for that kind of a thing. And it concerns me that members of the public are sort of required to say the magic words immediate disclosure request, or that they lose their rights under the Sunshine Ordinance for certain things. And that doesn't seem right to me. That's kind of a worry, because how is anybody supposed to know those magic words unless they come to these meetings and talk to lawyers and stuff? that's a pretty high bar, and I'm learning as I go. This is a really difficult system to engage in and understand and file with. It's just, I can't imagine many disabled people are able to navigate this at all, and kind of amazing that I've been able to. So I appreciate any consideration that task force members and staff can have around that. It's very different in the world when you can't walk or type an email, and you might struggle to wash your own dishes or cook your own food. It's just a different world. Also wanted to raise a concern about the deletion of public records for government employees that leave the service of the government, that leave their job. I've raised this concern previously. I will keep raising it, that I was told by Department of Technology that records, email histories, email records of public employees who leave their job without notice to anyone in those records, or even if it's a case that they're helping somebody with, that those records will be deleted permanently from all databases within 14 days. So you might not even know that someone helping you has left their job, and all your records are gone if you haven't requested them, not even knowing to request them in 14 days. That seems to me a pretty awful use of open government and the public trust, and to erase records like that is concerning. So I hope somebody can look into that. Thank you so much for your time and attention here today.
Do we have any other speakers? Last call for public comment. Chair Wolf, I think that's it. I think you're on mute.
Thank you. Yes, I was. Okay, thank you. Let's call the next item, and then after that next item, we're gonna have a recess for 10 minutes.
Item number 5, file number 20082, complaint filed by Library Users Association against Mary Giarduzzi and the Library Commission for allegedly violating Administrative Code Section 6715 by failing to allow participation in public comment during a remote Library Commission meeting dated July 9, 2020. So on March 23rd, the Education Outreach and Training Committee found jurisdiction, the record's public, and referred to the matter to the task force.
Okay, great. Okay, same call as before, folks. We'll have the petitioner speak first for 5 minutes, and then the respondent for 5 minutes, and then we'll have our discovery period, then rebuttals, and then deliberations and an action. Okay, if you're ready with the clock, Ms. Leger, we'll hear from Mr. Warfield from the Library Users Association.
Mr. Warfield, are you ready?
Yes, thank you. Tell me when to start, please.
Go ahead.
Thank you. This is Peter Warfield, Executive Director of Library Users Association. Our contact information can be found in the agenda packet, but for those who don't go there or are listening on a recording or in some other fashion, it's libraryusers2004@yahoo.com, and also P.O. Box 170544, San Francisco, California 94117-0544. This is a basically simple complaint. It basically consisted of 2 sentences that we sent to the task force the day after the Library Commission meeting a special meeting of July 9th. And I'll read you the core. At yesterday's special meeting of the San Francisco Public Library Commission, July 9, 2020, Library Users Association was denied the ability to make public comment on item 2, SFPL reopening plan, which was the major item on the agenda. This was despite my best efforts to alert the Commission of my intention at this remotely conducted meeting. Thank you for your attention to this. Sincerely yours. That's basically it. Now, there's been a bunch of material that I have supplied, and also there's a bunch of material that I haven't supplied and that we haven't supplied, some of which has been supplied, for example, to the administrator and so on and so forth. So let me just point out the key documents I think that would be useful for your reference. First of all, number 1 would be P45 to 50, what constitutes fair and reasonable access to public comment. Earlier, we sent to the task force asking very much for folks to attend an actual meeting under WebEx because we thought that it would be useful for you to attend via telephone, as we have been attending all the Library Commission meetings under COVID, and as many people are required to do because they don't have a computer, they don't have internet access, and so on. I think I've repeatedly mentioned the statistics which come from the mayor's office, fairly recent, that over 100,000 people in San Francisco don't have internet access, and certainly that minorities, older people, poorer people have the least access, disproportionately. So that was on P27 to 33. The complaint presentation, the introduction, was on P38 to 40. And we also made a little note of annotations on the library's instructions that were posted in the agenda and that were included in the library's argument, and that's on our, well, on the page P42. The annotations are hard to read. I'm disappointed that they aren't in the red ink that we actually sent. And the library's answer is on page P55 to 56. So basically, you've heard the complaint. We tried our best under the rules to make public comment, and we're not able to make public comment. I'm glad to say that approximately 2 months ago, the library changed its procedure during meetings in a favorable way. And that is, they very pointedly and clearly said that they were going to take a pause with regard to going to the next item when the gatekeeper, the person who from the library staff is controlling access to public comment, when that person would say, there's nobody waiting to speak.
30
now,
seconds.
You've experienced that sort of thing right here, where the chair, for example, says, let's wait and see if anybody wants to make public comment. They can press *6 and so on. So at the Library Commission, they pause. And I think that was key, and I think I recognized that at the very beginning and commented that that's key to giving people a chance to make public comment and to do so better. And I'm glad the library has changed that. I think it indicates they understand they made a mistake previously.
Your time's up, sir.
Okay, are there any persons or witnesses providing facts or evidence on behalf of the petitioner? Okay, seeing none. Is there a representative? I guess it's Miss Giarducci?
This is Margot Schaub. I'm the Library Commission Affairs Analyst. I'm here for the San Francisco Public Library.
Okay, very good. You have 5 minutes for your opening statement.
Thank you so much, and thanks for having me here this evening. In talking with folks for the meeting, I think this is one of the initial meetings coming back to do commission meetings, and looking at it is that the complainant had an opportunity to provide public comments, and looking at the minutes and videos from the meeting, he did on previous items and did not on this. It seems, we don't know, but there was a technical issue. I went over with the person who steers these commission meetings, and they showed me what it looks like when you raise your hand on the phone and when you don't. And if there's a hand there, you know who to call on, and you call on the phone number for the person who has their hand raised, but that's through WebEx. So we did not, San Francisco Public Library did not fail to allow participation in public comment. The public comment was not asked to be made. And as Mr. Warfield just said, I'm new to, well, he didn't say this, but I'm new to the role. And so I want to make sure that everyone who wants to make public comment can, and that was something that I asked us to institute, was to take a pause in case somebody is having difficulty with the technology, that we're going to be able to catch them. So again, it looks like that was a technical issue. A public comment was never asked, and so we were not able to enable Mr. Warfield to make a public comment. Thank you.
Is that the end of your testimony?
Yeah, no, thank you so much.
Okay, great. Appreciate it. Any persons or witnesses to provide any facts or evidence on behalf of the respondent?
No, sir.
Okay. It could be somebody other than from your department. It could be a member of the public. Yeah, anybody. Okay, hearing none, members, this is question and answer, clarification, or discovery. I've got member Padmanabhan and then member Stein.
So this question is for, I'd like to understand the technology. So this is for Mr. Warfield. Do you normally hear an announcement when you are toggled out of the queue? I have several leading questions from there.
It seems like a bad connection, but I think you're asking, do I normally hear if I am toggled out of the queue?
That's right.
Generally, the system provides a message, and presumably the toggling out of the queue is done by the gatekeeper. I call the gatekeeper. I think the technology calls it the monitor. It's the person who lets people in or mutes them out of being able to speak. So there's a couple of issues. One of the issues is, as I mentioned in some of my documents, the message that the system gives is given in a very soft voice, and there's a momentary pause, and it varies. It can vary. I don't know how it varies. I know in different meetings it varies and so on. So there's a momentary pause after you press *3, and then there's a very soft voice who has rather a long message, which I think I've quoted in the documents. If you press *3 again, you get a similar message, but one of the key problems is it's very hard to understand because there is not a silence, as the library's instructions say, but instead there is a simultaneous sound of the system soft voice saying you've basically raised your hand or lowered your hand, simultaneous with the meeting going on. And so that's very hard to understand, and even sometimes hard to know that something was actually said. I was hoping that folks would have that experience. Now, there's another thing that evidently also can happen, and that is the libraries, whoever controls it, can also just sort of gang lower everybody's hand. And if that happens at a time when either the person taking part is not attentive, or it maybe isn't going to be my turn to make public comment for a while, I may not even be at the phone. If I've made public comment and then raised my hand, I go away to get a cup of coffee or a drink of water, and now while I was gone, there was an instantaneous message, as there actually was at today's meeting. Nobody else hears it except the people with their hands up, as I understand it. and they say the speaker queue has been cleared or some such kind of a thing. That actually happened today, and Mr. Carnazes actually spoke about it, and I heard it also. So now you've gone away momentarily or inattentive, or there was noise, or the message couldn't be heard because people were talking during the meeting. And now your status is reversed. You thought you had your hand up, but when they start calling on people, you're waiting and waiting, and then they don't call on you. So there's a whole range of problems, as far as I'm concerned, that I'm already aware of, and I certainly don't think that I know everything about the system and how it works. But one of the things that's very clear is that nobody who's on the video, for example, is going to hear my message that I'm getting saying everybody's hands have been lowered, or certainly not that your hand is up or your hand is down. I hope that explained it, and I'm very happy to answer questions to the best of my ability. I'd be very happy for that. And I might be able to play you an example of the simultaneous talking where it's very, very hard to understand what's happening.
Okay, thank you.
All right, we're getting a lot of background noise. Could folks please mute themselves? We have many people on the phone that are unmuted. Please press *6 to mute yourself. Thank you. We have Member Stein and then Member Highland.
Okay, so I just have a couple of questions for the respondent from the Library Commission, as well as one question for Mr. Warfield. So for the Library Commission respondent, I'm wondering if you wanted to comment on some of the technical issues that Mr. Warfield identified as problematic. First, the idea that *3 acts as a toggle that participants may not be aware of. This issue of multiple competing voices being heard by a caller that might make it confusing whether they are able to participate or not, or whether they're in the queue or not. And then there was this thing about toll charges, and I'm not entirely clear about that, but I'm wondering if you have any comments on any of those technical issues.
I don't know about the toll charges, and I don't run the meetings through WebEx, so I can answer what I know, which is it's easier to participate over WebEx than it is by phone. I do know that if you press, and I should go back and say this, the library has put out on each of its agenda how you can join a call. And so we have given directions on how you join it by phone and how you join it by WebEx. One thing I'm aware of is if you are somebody who presses *3 early to say that you want to do public comment way before public comment is called, and then if you do it again because public comment is called, your hand goes down. So that could be an issue. But again, I don't know what issue Mr. Warfield faced, but again, if he walked away and something happened, that's a technical issue. That was not the library doing something. It's either a technical issue on his end or there was a technical issue in the meeting. So.
Okay, so and any comment about multiple competing voices being heard by a caller?
So right now, when I just press *6 to come back in, somebody talks to me so I can't hear what you're saying. And so that is an issue. I don't know, I'm not an expert at WebEx, but I do know that I couldn't hear you talking for maybe 2 seconds, not even, it was about a second. So people don't cross talk in our meetings because everyone's muted until you raise your hand and you're called on for public comment. So I don't know what the crosstalk would be that he's referring to.
Okay, thanks. And then my question for Mr. Warfield is, you mentioned that they are now instituting kind of a pause to check whether anyone might be having technical issues and ensuring that people can be in the queue if they want to be. Were there any other procedures that you had in mind that you feel like would be a remedy to the technical difficulties that you identify?
Well, certainly the pausing, which you do all the time, and in your meetings, even folks I understand and I can't see that are doing it directly through WebEx forget to unmute themselves. They forget this, they forget that, they, you know, whatever. It's normal to say, okay, let's try and adjust for that. And the library particularly not only didn't adjust for that, but they, you know, a lot of their procedure is problematic. For example, when they say caller number 6 or caller number 2, your time begins now. Well, they start the timer whether you're talking or not. If you ask a question, can you hear me? The timer seems to be still going, but you know, it makes tension over straightening out any kind of technical difficulty. And I have actually asked several times at different meetings, will you give me a 30-second alert, please? Because in a regular library commission meeting, there's a big square timer sitting counting down, and you can see at any moment in your 3 minutes, 2:59, 2:58, 2:57. So at any moment, you can look up and see how much time you have left. At the supervisors, similarly, the podium has a countdown. And at the task force, you routinely give 30-second warnings. The Library Commission won't even answer. I've had several occasions where they will not answer. I leave a blank few moments, and then I say, well, I guess I won't get an answer. And I've had the city librarian say, Mr. Warfield, you can go ahead, or go ahead and speak. You know, which is frankly, pretty insulting. As far as Ms. Schaub's understanding of contention, which is what happens when two voices are speaking at the same time, I'm not sure what she is referring to. If I press *3, or whatever I have to press *3, I can press that any time in the meeting. Up, down, up, down. I can do it throughout the whole meeting if I want to. Not that I'm doing it. But if I do that, for example, after public comment is over on item 1, and I figure, okay, next up is item 2, they're going to discuss this one a little and then go on, I press *3. I'm pressing *3 while the commission is talking about, let's say, item 1. And they're talking the whole time. There isn't a lot of space where they're talking. They talk. And so I'm going to hear the message about my hand up or my hand down while they are talking. So, you know, those are some of the problems. I could probably give you a list of other issues, but right now, I mean, you mentioned, I believe, the toll charges. And by the way, I'm glad you're asking. I'm grateful you're asking. It is something that I found a problem also, and mentioned it. Toll charges meant that if you wanted to participate in the Library Commission meeting of that date and the prior date, and I'm not sure how many dates further, you literally had to call a toll number which was in San Jose. And I called up the O operator multiple times, and they told me from a AT&T landline, which I'm speaking to you on now at home, your cost is 59 cents a minute plus tax. Well, that's kind of a lot. And they've changed it since then to a local call, but at that time, and I'm looking at the library's response, I don't know if this was the current response. I'm looking at page 55. And let me just see where the number is. So yeah, on page P for Peter 55, the library's own response says, right up in the agenda, listen and public comment calling. Should I pause for a minute to let people look at it? So the number is 1-408-418-9388. Then it gives the access code and so on. So you had to spend a fortune or find some other way. Frankly, I don't even know that that's legal within the concept of sunshine, that you should be able to attend a meeting without any charge. But that was certainly a very steep thing to do. And for those who might have a cell phone connection there where it's cheaper, or no extra charge for them, they're then forced into using an inferior kind of a connection where it's even hard to understand when there's no crosstalk and no contention with any other voices at the same time as the meeting voices. So those are some of the things that could go on. Yeah.
We have other folks that want to ask questions.
Sure. Yeah, please.
Okay, thank you.
Okay, Member Highland and Member Schmidt.
I had a question for Ms. Kaplan. I think you said in your opening preamble that public comment was not called at that particular item. Did I hear that correctly?
Are you talking to Margot Shaw or is there a Kaplan?
I apologize, Ms. Shaw. Yes.
Oh no, public comment is called on every item. I know Mr. Warfield had made public comment on the item before and on items afterwards, so we just knew that he had the capability of doing that. So
okay, I thought I heard you say that perhaps there's a technical glitch where public comment was not called on that item. Did I mishear?
That's not what I didn't say that, but what I did say is that if you can, as Mr. Warfield said, you can toggle on and off by raising your hand. We can't do that to him, but he can do that, or a commenter can do that. So if he did if he pressed star 3 and then accidentally did it again and walked away and got coffee and didn't hear what have you, then he did not make a public comment, but we do call public comment on every item, and we did that day.
All right. Okay, that's all. Thank you.
Sure.
Yep. Member Schmidt.
Yeah, 2 questions for Mr. Warfield. First, about the meeting in question, that specific meeting, that specific day. So were you did you have to call a 408 toll number to get into that meeting?
Yes, absolutely. That's the only number that's listed on the agenda that I could see was available. Yes.
So I assume that you ended up probably with a charge on your phone bill to call in.
I decided that for the sake of the enormous charge, I would be willing to accept a very degraded flip phone, which would cost me less.
Okay.
But it was still a cost. It was still a greater than. It was above 0 for sure.
Now, when you had the difficulty where there was an item and it was a point where public comment was being taken, and you weren't able to make a comment on that matter, were there subsequent items at that meeting where you were able to make comment?
Yes, absolutely. In fact, I'd made public comment on the first item and the subsequent items, of which there were, I believe, 2, and at the first meeting in June that they had under COVID. So I made public comment there as well successfully.
Okay. Did you bring up, in the subsequent public comments, did you bring up this issue that on a prior item, your comment was not made, and so you needed that problem remedied?
I certainly did. On the immediately following item, I spoke up immediately. And by the way, this is another tension point. How much of my time do I want to spend complaining about some kind of a problem that I've had on a previous item? And am I going to run into flack from the Library Commission over, well, that's not relevant. The issue now is item 3. But I certainly did make a comment, and I believe I even put my finger on something that ultimately 9 or so months later they've done, which is take a pause And if anybody has misunderstood or been misled or just doesn't know or can't remember or whatever it is, their status, just as you guys routinely don't remember that you're muted and somebody has to say, hey, please, okay, fine. That's an accommodation. That's a reasonable thing. I wanted to say something about Ms. Schaub, that she said they can't change my status. That is not true. You've just done it today at the meeting. The library is able, without anybody in the meeting hearing it, as I understand it, and I've experienced it, at this and other meetings, where the library gatekeeper who controls admission into the room for sound, for making public comment, is able to lower a person's hand or lower, I believe, everybody's hand whose hand is up. So the reversal is entirely possible within their control.
When you mentioned at a subsequent public comment that you had not been able to make your public comment on the prior item, did anyone with the commission allow you to go back and to put your comment on that item?
What a lovely thought. I appreciate that very much. No, absolutely not.
Okay, so
And
they
as I
didn't
said,
offer to accommodate
Pardon?
you in any way?
That's correct.
Okay, got it. Okay, thank you. I think that's what I was looking for.
Okay, thank you. Member Forsley.
Hi, yes. I was wondering for the library commission or library representative, do they remember Peter Warfield subsequently referring to not being able to make public comment?
I'm new to this role, but I did watch the commission meeting. And so I did see that he seemed frustrated that he couldn't make a comment, or that he said he couldn't make a comment.
And so just a follow-up question, since you had seen that portion of it immediately preceding that, you state that public comment was called for in the item that he was referring to?
I'm not sure I understand your question, but if what you're asking is, when I watched this, I saw that he was able to make public comment throughout the commission meeting. Yes.
Okay, yeah.
Any other questions on discovery, folks? Clarifications? All right, I have one, Ms. Shaw. What system do you use exactly?
The platform is WebEx.
Okay, and is the phone service also provided by WebEx?
Through WebEx.
Okay. I thought I heard you say that that the phone service was not WebEx before.
I
Right.
don't have enough technical information. No, it's a WebEx platform, and that's what we use to run our commission meetings. So the phone is part of the WebEx system that they provide to us when we use their product.
Okay, great. Okay, that's what I wanted to know. Okay, thank you very much. Members, are we ready for rebuttal? Your last chance for Q&A. Okay, let's move to rebuttals. Ms. Shaw, you go first. You have 3 minutes.
Are you ready?
Yeah, so Margot Schaub's going first.
Yes.
Okay, I'm ready when you are.
Okay, go ahead.
Just wanted to reiterate, I'm new to this role, and we did institute a pause to make sure that we did not miss people who were having technical issues with the WebEx platform, so they could make public comments. We were not missing people making public comments, although this is the only one I've heard of since I've started. And thank you for inviting me tonight and hearing me, and I have nothing further to add.
Thank you. Mr. Warfield, you have 3 minutes.
Hang on.
Can you tell me when to start, please? I'm not clear.
Yeah, you can start now, Mr. Warfield.
Thank you. First of all, the calling of public comment, that is done, but the opportunity to make public comment requires me to be able to speak. If you locked the door and call it a technical problem, well, yeah, I can't walk through a door. I'm very interested. I'm glad Mr. Wolf asked about what system was being used, because I heard it too, that we're not using WebEx. And now it turns out we are. I'm interested in what the technical issue is, but in any case, as far as I'm concerned, it is the responsibility of the Library Commission to provide an opportunity for public comment, whatever it takes. And certainly if there was a problem with a microphone, if somebody gets up there and they're too short or too tall, people will say, oh, please adjust the microphone, or if somebody is slow in getting to the podium, and so on and so forth. I provided in my documentation that the library's argument about nobody else had a problem, first of all, it's irrelevant, because all kinds of things can be different for different folks, different circumstances, statuses, hands up or hands down, and so on. But in fact, Mr. Hasbrook was called on specifically to make public comment, and about 17 seconds of waiting through silence found that he wasn't able to make public comment. And so he came back on as something like the seventh person speaking, and I'd be glad to play it for you if you let me play it, but I have it on page your P49. Item 13, others have complained about public comment during COVID-19, including 2 people at the July 9th, 2020 meeting that we attended. And the first one I said 13A, Edward Hasbrook, exactly at 10:07. He was called to speak on. There was a silence. No, it didn't seem like it was happening. And then later, 7 minutes later at 17:10, if you play it yourselves on one of your computers, you'll hear him say, very sniffy and very not happy. I did try to call in on WebEx, and that wasn't working, for your information. And by the way, they called on him by name at 10 minutes and 7 seconds into the meeting, and he wasn't to be found. So he very snippily said it wasn't working. And then Anonymous also complained about the barrier of expensive toll charges, and that's actually mentioned in the minutes of the July 9th, 2020 meeting, if you want to look that up as well, and I actually appreciate it if you would. So we did our best against a lot of uncertainties and odds. I would certainly ask what were the technical issue that Ms. Shaw is blaming for this. Let's hear it, and I think they still are responsible, even if no matter what the technical cause is. Thank you.
Okay, members, time for deliberation and an action. So I have one thought about this is, at the time that they were of these meetings that they were using, not just in one meeting, but in multiple meetings, a long distance number, and considering it's out of the what they call LATA, it's a local area telephone access or something like that, or local access telephone area or something like that. If you're using a landline, it is a long distance phone call to 408, which is San Jose. It is quite expensive. I agree with that. There cannot be an assumption that everybody is using a cellular phone, which most plans include long distance. So I'm wondering if that might be considered a barrier to access of a meeting. It's an interesting point.
Member Schmidt, I'd agree that looks like a barrier to access that is probably a violation here. It's unclear if it comes within the scope of the claim itself, but it did happen on the day of, in that moment that he was being charged money to attend a meeting by calling a 408 number.
Okay, so if there's no other deliberation or discussion, is there a motion? You need a motion one way or another.
I will make the motion. This is Member Schmidt, to find a violation of 6715, failing to allow participation. And at least at this time, I'd also like to make a finding of a violation of 67.13A, requiring a payment or purchase in order to attend.
Okay, moved by Member Schmidt. Is there a second?
I'll second. This is Member LaHood.
Moved by Member Schmidt, second by Member LaHood, to find a violation of 6715 for failing to provide opportunity for public testimony, and a violation of 6713A for requiring a payment or purchase to attend a meeting. Any discussion, debate on the motion? Vice Chair Yankee.
Yes. I don't know if this would apply, but maybe it's worth discussing. There's 67.6B, talks about a lot, but ends with all meetings of its policies bodies shall be held within the city and county of San Francisco. And so I wonder if the fact that this area code is not within the city and county of San Francisco, if that provision would virtually apply, for lack of a better way to put it.
Are you making an assertion, or are you asking a question?
I was raising a point of discussion.
Okay.
I don't know if anyone else has a thought on that.
Well, we have a motion on the floor. If let's continue with that motion, unless you're one of the maker or the second wants to amend the motion to include that. Otherwise, I would say let's deal with the motion on the floor. We could discuss it afterwards. If it's another motion would be made, then we can do that too.
That works for me.
Okay. Any other debate or discussion on the motion? Okay, let's call public comment. Public comment is on the motion to find a violation of 6715 and 6713A. Mr. Leger, I hand it to you.
Do we have any speakers? This is calling for public comment on the motion. Find a violation of 6715 and 6713A. we have any public comment?
Yes, anonymous, please. Hello?
I hear
Hello?
ya. Yep, just
Oh.
a second. Can you hear me?
I can hear you now.
Okay. You ready?
I am.
Go ahead, sir.
So exactly what Mr. Warfield said happened to him just now happened to me. I was sitting there saying anonymous number one, but I had to swap my *6 back in, not realizing I had been *6 in between. But this violation is important. I would say both the ones that you're in your motion now, which I support, but also the one that was suggested about the location being inside San Francisco, because it's not just about some meeting that happened months ago. This is how the city is going to set its standards for other virtual meetings and if there's another pandemic or emergency. And just like in a physical, real-life meeting, if you ask for some public comment and someone is sitting at the back and they need a walker to get to the front, and they say, well, there's no one at the podium, let's move on, that would not be giving that person a meaningful opportunity to comment. And the same exact thing applies to, for example, as I just experienced, having to press *6, I just had to sit through some comment that I'm saying, and I don't know if you know I'm trying to comment. And so this matters, and it's the meaningful opportunity to comment that matters. Just performative asking for and then moving on doesn't count. And by finding this violation, you'll ensure that all other commissions properly set their rules going forward. Thank you.
Do we have any other public commenters? Chair Wolf, I think you're on mute.
Thank you. Let's close public comment and any other last debate, or are we ready for a vote?
Member Schmidt, I really like what Member Yankee said, and it's a good idea. I think it's ambiguous though. Where is a meeting held, if anywhere, if it's not held physically? I mean, I'd be willing if others want to add that to my motion, but I don't know if it's that clear whether there was a violation of that. So that's my response on that.
Well, I would say, the meeting in question was not during the pandemic. The meeting in question, was it? Oh, yeah.
So July 2020.
July 2020. I'm sorry. Yes, it was. Okay. I think so then I'll say this. Because virtual meetings were allowed under the shelter-in-place ordinance or declarations, it's a bit of a reach for me to say that the meeting didn't happen, in a physical place, and I would at least say that the access to it needs to be in the locale of San Francisco, which would require a 415 area code to access. I can't even think of an analogy that I can bring to that. I think it's just as plain as that is. So I would hedge against Vice Chair Yankee's suggestion. But I do understand it. I think that is important. But I think as long as access to a San Francisco meeting remains free of charge. That it contains all the ability to access from within the confines of the city. I think under the shelter-in-place order, I think that would be reasonable. I think outside of it, like if the shelter-in-place order was lifted as it's planned to be on June 15th, and city buildings are still not open for public meetings, and we're still doing this remotely, then I think there's an issue. We can take up that issue at that point if meetings are happening not in the confines of the city. I'll stop there. Member LaHood.
Yeah, I just wanted to support that. I agree, and as the second on this motion, I agree with what you just said, and that either a 415 number or a toll-free number to ensure that there were no barriers to access would have been sufficient. But anything where some members of the public, in order to call in, would have to pay is not acceptable.
Okay. All right. Any last thoughts? Are we ready for a vote? Okay. Please call the roll.
Member Schmidt?
Aye.
Member Schmidt, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Frazier, absent. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Yankee, aye. Member Highland?
No.
Member Highland, no. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to find a violation of 6715 by failing to allow participation in public comment, and 6713A requiring a payment or purchase to attend the meeting.
And the tally?
9 to